Lawyers for Dr Nandipha Magudumana argue that the Supreme Court of Appeal can reach a different conclusion on their client's application to declare her arrest and deportation unlawful. They say the state's unlawful extradition in late April cannot be made lawful by consent. In June, the Free State High Court ruled that her extradition was disguised as a deportation. However, it dismissed her application on the basis that she consented to returning back to South Africa. Judgment on leave to appeal the application was reserved and will be handed down on Tuesday. Newzroom Afrika's Mnisi is following proceedings and filed this report.
At the center of Dr Nandipha Magudumana's appeal is the consent that she gave to authorities prior to being extradited back to South Africa. In its judgment, the Bloemfontein High Court ruled that Magudumana was well aware at the time of her handover that charges could be leveled against her upon arrival in South Africa, but nevertheless consented to returning because she wanted to be reunited with her children. But she denies consenting to returning home, adding that consent would need to be fully informed.
When was consent made? To whom was it made? Under what circumstances was it made? Is it clear? Is it unequivocal? Is it in writing? None of those facts appear in the answering affidavit.
The state was adamant that Magudumana was deported lawfully. It said the Tanzanian authorities exercised their discretion to use their unilateral system of deportation and slapped Magudumana with a notice of prohibited immigrant. However, the court found that the Department of Home Affairs knew that Magudumana was handed over to them in Tanzania for the purposes of prosecution, and this was in fact extradition without following any extradition processes. Magudumana's lawyers now question the role of the police, who said their part was to escort the Home Affairs Department, as Besta was a convicted and sentenced murderer, and that Magudumana informed all and sundry that she wanted to return to South Africa to be with her children.
Is it appropriate for SAPS who say, I am not involved? All I was doing there was offering protection to the officials of Home Affairs to take the consent argument. My Lord, with respect, that in and of itself is dispositive of the unequivocal consent provision. Because if you have two conflicting views by respondents, how can there ever with respect be unequivocal consent? If one party says, I exercised an arrest power in a foreign country, and another party says, no, there was consent. The respondents themselves are confused as to what the correct route was.
The state is, however, adamant that there are no reasonable prospects for success and no compelling reasons for the court to grant leave to appeal. It says Magudumana said to everybody who would listen that she wanted to go home.
The moment she acquiesced or consented, there was no unlawfulness, there was no illegality.
The state says one of the cases that Magudumana's lawyers relied on was not specific in the form of consent needed.
It is said that there is a Muhammad test. And once more, what you've been referred to, my Lord, is the footnote and the academic scholars and what they say. Muhammad, the case itself, the heading of the passage, where the court deals with this, at paragraph 61 of that judgment, says consent to deportation or extradition. Nowhere in this judgment, my Lord, will you find the Constitutional Court in Muhammad requiring consent or waiver to be in writing.
The court has reserved its judgment till the 18th of July. If Magudumana succeeds, then she will head to the Supreme Court of Appeal to overturn the ruling that dismissed her application to have her arrest and deportation declared unlawful. For Newzroom Afrika on Channel 405, I'm Mnisi in Bloemfontein.